Hello, and welcome to the September 2020 Healthcare Facility Do Not Resuscitate Orders Education. My name is Michael Economides. I am the Senior Associate Legal Counsel for UMC Health System. And before we get started, let me give you our traditional disclaimers. The presentation is informational only. It is not intended to convey legal advice or to reflect the opinions or positions of University Medical Center, the UMC Health System, or the Lubbock County Hospital District. The information is current as of September 2020. If you need legal advice, please contact your institution's legal counsel. So with that, let's begin. What are we doing here? Senate Bill 11, titled General Procedures and Requirements for Certain Do Not Resuscitate Orders, passed the legislature on August 16th of 2017 during the called session. It became effective April 1st of 2018. It created Healthcare Facility Do Not Resuscitate procedures. The Department of State Health Services adopted rules effective September 20th of 2018. Now, DISH pointedly declined to explain or to clarify the laws, and the rules themselves we will not be addressing here. That's unnecessary anyway. The rules essentially just restate the law. So what we have here are procedures and requirements for do not resuscitate orders. More ominously, the extended title of the bill is General Procedures and Requirements for Certain Do Not Resuscitate Orders, creating a criminal offense. Now that we have the background of the law out of the way, let's talk about some definitions. You'll see at the bottom of the slide, we're referring to the Advanced Directives Act, which is Texas Health and Safety Code, Chapter 166. The reason is the text of Senate Bill 11 amended Chapter 166. So all of the definitions that you'll see come out of that chapter and affect how we understand and interpret the Healthcare Facility Do Not Resuscitate Order procedures. The first definition that I'd like to get into is a Do Not Resuscitate Order. What are they actually talking about? A Do Not Resuscitate Order is an order not to attempt CPR on a patient whose circulatory or respiratory function ceases. Now that's very important. We're not talking about a patient whose circulatory or respiratory functions are malfunctioning, but their function has ceased. So not to attempt CPR on a patient whose circulatory or respiratory function ceases. Cardiopulmonary resuscitation, CPR, is any medical intervention used to restore circulatory or respiratory function that has ceased. Again, not that has malfunctioned, but that has ceased. Attending physician is a physician who has primary responsibility for a patient's treatment. Now, the Texas Hospital Association and Senator Perry, by the way, our local state senator, has asked DISH for rules to clarify that attending physician includes any physician providing direct care to the patient. DISH declined. They said that's beyond our scope. The statutory language requires that an attending physician means primary attending physician, not any attending physician, but primary attending physician. Senator Perry and Representative Bonin, among other legislators, have requested DISH to provide definitions for other terms and phrases as well, such as soon as practicable, or competent, or direct care, imminent death, incompetent, medical appropriateness, promptly notify, reasonable effort to transfer, and reasonable medical judgment. Again, DISH declined. They said, again, this is beyond our scope. We're not going to talk about that. Now that we have the background, our next set of definitions begins with qualified patient. A qualified patient is a patient who has a terminal or irreversible condition diagnosed and certified in writing by the attending physician. It's very important. It's not the patient does not just have this condition or have a condition that is terminal or irreversible, but has this condition that is diagnosed and certified in writing by the attending physician. So there's a documentation process, and the attending physician is the one who has to do it. And a qualified patient essentially is a patient who is qualified for hospice. The terminal condition is an incurable condition that will produce death within 6 months. An irreversible condition is a condition that may be treated but is never cured. that leaves a person unable to care for or make decisions for themselves, and that without life-sustaining treatment is fatal. Our next, what's new? What is it that Senate Bill 11 does? Senate Bill 11 creates healthcare facility do not resuscitate orders and procedures, really, but consent requirements, order requirements. But healthcare facility do not resuscitate orders. And the orders differ in scope from out-of-hospital DNR orders, and we'll see in just a minute how they differ. These healthcare facility do not resuscitate orders apply in hospital settings other than ERs or outpatient areas. So you think inpatient or OBS, but not in the emergency department or in any or outpatient surgery, for example. They won't apply there. Additionally, besides the orders, SB 11 specifies consent requirements for healthcare facility DNRs. And with that in mind, let's take a few moments to compare out-of-hospital DNRs with healthcare facility DNRs. What's new? So let's take a moment to compare out-of-hospital DNRs, which you may be very familiar with, and the newer version, the healthcare facility DNR that's our topic for today. An out-of-hospital DNR has a mandated form. If you've ever seen one, they are very detailed, fine print, a lot of steps to go through, but the form is actually pretty good. It walks you through the process fairly well. And once you walk through the process, you have certain signature criteria, and the signatures either have to be notarized or they have full witness requirements, according to Chapter 166, Section 003, which requires that both witnesses be competent adults, and the two witnesses cannot both be primary and alternate agents under medical power of attorney. They cannot both be relatives of the patient. They cannot both be heirs or claimants on the patient's estate, although how would anybody know that? And the witnesses cannot both be employees who are providing direct care to the patient. That last clause is crucial. It does not say that one of the witnesses cannot be an employee of the attending or of the hospital. It says there cannot be an employee of the attending physician or of the hospital who is providing direct care to the patient. There are other requirements, other witness requirements, but that's it in a nutshell. And again, we will talk about the specific witness requirements for healthcare facility DNRs in just a moment. Out-of-hospital DNRs allow for withholding of cardiopulmonary resuscitation, advanced airway management, artificial ventilation, defibrillation, transcutaneous cardiac pacing, and other life-sustaining treatment specified by DISH. To this point, DISH has not specified any other life-sustaining treatment other than what you see on this list: CPR, advanced airway management, artificial ventilation, defibrillation, transcutaneous cardiac pacing. DISH has put out an FAQ that defines some of these ideas on a kind of a layperson level for CPR. And remember, CPR has a legal definition: any medical intervention used to restore circulatory or respiratory function that has ceased. The kind of lay definition that DISH has provided is pushing down in the middle of the chest when a heart has stopped beating to help the heart beat, and breathing into the lungs through the mouth to fill the lungs with air for a person that has stopped breathing and whose heart has stopped beating. Transcutaneous cardiac pacing, again on a lay level: pads put on the outside of the chest so an electrical impulse can be sent to the heart to try to regulate certain irregular beats that could be dangerous to a person's life. Defibrillation: an electric shock put through the chest to try to start their heart beating again when it has stopped, which again kind of overlaps with the CPR definition, but we'll leave that be as it were. Advanced airway management: when trained people put what looks like a clear tube into a person's mouth when that person has stopped breathing or is not able to breathe well on their own to breathe for them. Artificial ventilation: when trained people use a football-sized bag and a mask that fits over a person's mouth and nose to push air into the lungs when the patient cannot breathe on their own or have stopped breathing. I would say this also includes automated mechanical ventilation as well. So this is their lay definition. Again, this is not the full definition. DISH has not specified any other treatment as life-sustaining for out-of-hospital DNR purposes. So let's compare that to healthcare facility DNRs. Whereas the out-of-hospital DNR has a mandated form, healthcare facility DNR procedures permit verbal consent and use other directives without a mandated form. There are truncated witness requirements for oral consent. The written consent does not require witnesses. It's just the oral consent. And we'll talk about it in a minute, but it's a shorter list than what I went through a moment ago. There is no notary or witness requirement for written healthcare facility DNR consent. Most importantly, though, is the scope. Healthcare facility DNR only allows withholding of CPR. It does not allow withholding of advanced airway management, of artificial ventilation, of defibrillation, of transcutaneous cardiac pacing. It only applies to the withholding of CPR. So, as we're thinking about that, keep that in mind as we go forward. Now let's talk about some of the healthcare facility DNR consent requirements. The law allows for 3 basic options for consent for healthcare facility DNRs. The first is dated written directions, and it's really that simple. A patient could write out their directions. I don't want CPR. Put the date on it, they're good. It doesn't technically even require a signature. The second option is witnessed oral directions. We've talked about the witnesses a bit, and we'll talk about them a little bit more in a moment, but witnessed oral directions is option 2. Option 3 is a directive to physicians, aka a living will, which can be oral or written, and it's not effective unless the patient is qualified and incapacitated. There are 3 other options for consent. 2 of the other 3 build off of these 3, and the last option is not really a consent option at all, although it's sometimes called physician consent. But these are the 3 basic options: dated written directions, witnessed oral directions, or a directive to physicians. The law. All right, so the witness requirements for healthcare facility DNR. Now, this only applies to oral healthcare facility DNR consents. But for oral healthcare facility DNR consents, each witness must be a competent adult. Now, how can you tell if a witness is competent? I don't know. But that's what the law requires. Also, we're not terribly clear that sometimes whether they're an adult, but I digress. And at least one of the witnesses must be a person who is not an employee of a healthcare facility or of the primary attending physician in which the declarant is a patient, if the employee is providing direct patient care. Again, it's the same kind of idea that we talked about a minute ago, and you can think of it this way. Witnesses cannot both be employees who are providing direct care to the patient. The last clause, again, is crucial. It does not say that one of the witnesses cannot be an employee. UMC often asks health unit coordinators to be witnesses. Now, unlike oral directives to physicians or out-of-hospital DNRs, the attending does not have to be present for oral DNR consents, but both have to be witnessed. Also, unlike directives or medical powers of attorney, oral healthcare facility DNR consents must be witnessed, not notarized. There's no notary option for a healthcare facility DNR consent. How do you notarize an oral consent? All right, so we've talked so far about the general situation where you have a patient who wants to consent to a healthcare facility DNR. What if the patient lacks capacity to make medical decisions? Well, then you go to guardians, agents, surrogates. First, we'll talk about as a guardian. If the patient has a guardian of the person, there you can either be a guardian of the estate or a guardian of the person, sometimes both, but guardian of the person is the one we're interested in. And this guardian of the person must have authority from the court to consent to medical treatment. And you'll find that authority in the guardianship order. If that authority is granted, then there's no need to document incapacity because the court has already done that. Generally speaking, if a patient lacks capacity, then the primary attending has to assess the patient and document that the patient lacks capacity before anybody else can make decisions on that patient's behalf. If there's a guardian already, again, the court's already made that determination, there's no need to do it again. It's always a good idea, though, to get copies of the guardianship order and the letters of guardianship so that you can determine the scope of the guardianship, and that's part of what we do in legal. If there's no guardian, but the patient lacks capacity, then an agent under a medical power of attorney can make decisions, can consent to a healthcare facility DNR on the patient's behalf if the primary attending documents the patient's incapacity. If there's no guardian or agent, then the following rules apply. The primary attending must document the incapacity, but they must also document that the patient is qualified, again, has a terminal or irreversible condition. And once the primary attending has documented the incapacity and the terminal or irreversible condition, then you go down a priority list of potential surrogate decision makers. A spouse, if there's a spouse, the spouse takes priority over everybody else. No spouse, then you go to a reasonably available adult child. None of those, then a parent. None of those, then nearest living relative. None of those, then you go to the two physicians. If you're familiar with the two-physician rule, that's basically the attending physician with another physician who is not providing direct care to the patient or who is a member of the ethics committee. They can make the decision on the patient's behalf. Now, it's important to realize that surrogates can, although they can consent in the situation where you've got a patient who's incapacitated and who's also a qualified patient, they cannot revoke DNR consent, which more on that in a moment. Another limitation is that whereas a guardian or an agent can exercise options 1, 2, or 3, they can do written, dated directions, they can do oral witness directions, they can do a directive to physicians. Surrogates can only use options 1 or 2, the dated written directions or the oral witness directions. So there are some limits on what a surrogate decision maker can do as far as healthcare facility DNRs go. I mentioned before that in some circumstances, the primary attending can enter a healthcare facility DNR order without explicit consent from the patient or the patient's decision maker. And we sometimes call this physician consent. I'll call it medically appropriate consent. One way or the other, whatever you call it, there are certain criteria that must be met before that can happen. The first is that the patient gave no instructions that contradict DNR. The patient can't have said, "I want everything done." If they've done that, if they said, "I want everything done," then the primary attending cannot enter a healthcare facility DNR order. The patient's death has to be imminent, regardless of CPR. Now, we don't really know what imminent means precisely, or what medically appropriate means precisely. Imminent probably means within minutes or hours, regardless of CPR. Again, we don't know. Senator Perry and everyone else has requested DISH to define the term. That hasn't happened. And the DNR order has to be medically appropriate. Now, again, medically appropriate is not defined. You have to use professional judgment at that point, and I leave that in your hands. If the situation meets these criteria, explicit patient consent is not required. I call this, again, the medically appropriate DNR option. You may hear it as the physician consent, as in the physician is consenting to the DNR. I mentioned before that now that we've discussed the various consent options, I thought I'd give you a look at what UMC's do not resuscitate or consent and attending physician order, the paper form, what it looks like. So it may be a little bit difficult to read, but this kind of gives you a little bit of an overview of what we're talking about when we talk about a consent and the actual form involved in it. Revocation. Who can revoke a healthcare facility do not resuscitate consent? The patient, the patient's guardian, or the patient's agent under a medical power of attorney. The primary attending can revoke, but only if the primary attending is the one who issued the medically appropriate DNR order. In other words, they didn't have actual patient consent. Surrogate decision makers cannot revoke DNR consents. I mentioned this before. Surrogate decision maker DNR consent can have unfortunate results. And once consent is revoked, a physician providing direct care to the patient, in other words, not necessarily the primary attending, a physician providing direct care must revoke the order. So if you are made aware that the patient or the patient's guardian or agent has revoked the consent, you must revoke the order. Has to be done. Revocation. Up to now, we've been discussing the consent to a healthcare facility DNR and the revocation of that consent. Now we're talking about the order itself, placing the order. Now, the order must be placed by the primary attending physician. The primary attending has responsibility. Verbal orders may be acceptable, but the primary attending must still sign eventually. Hospital policy controls verbal orders. SB 11 does not control. It didn't address it, and DISH has declined to address it either. UMC policy currently permits verbal orders. 2 nurses may accept, witness, and enter the verbal order under the primary attending, who has to sign within 24 hours. The order is not effective until signed. And SB 11 also does not, although it does not specifically address carryover, the orders carry over encounter to encounter. That was the legislator's intent, even if it didn't say it in the bill itself. The order is ostensibly valid until revoked. The consent is valid until revoked, and so must the order be. We're still in the process of making that practicable. Up to now, what happens when the primary attending and the patient or the patient's decision maker cannot agree on whether or not to issue a healthcare facility do not resuscitate order? The first thing that has to happen, if the primary attending does not wish to issue or to comply with a healthcare facility DNR order, is that the primary attending has to inform the patient or the patient's decision maker of the benefits and burdens of CPR. If a dispute remains, there has to be a reasonable effort to transfer care of the patient to a new physician or to a new facility. Now, the legislative intent, in other words, it's not explained in the bill, but we know that this is what they intended, is that these disputes concerning DNR orders or patient's instructions regarding CPR are not subject to ethics committee hearings, to medical appropriateness or futility reviews. And it's really unclear at this point how the two procedures would jibe. We haven't really run across too many problems with that, at least that I've been made aware of. And arguably, the procedure here for healthcare facility DNRs provides less protection for the patient than the usual medical appropriateness review or ethics committee hearing. That's a digression. We won't get into it, though. So we've talked so far now about the background of the law. We've talked about how the consents work. We've talked about how the revocation works. We've talked about issuing the order, and we've talked about disputes. So now let's go through a few scenarios. What happens when scenario 1, when the patient has capacity to make medical treatment decisions? Although it isn't strictly required, I do recommend generally having the primary attending document capacity, making some note in the record. And once that's done, the patient can use option 1, 2, or 3 to consent to a healthcare facility DNR. Option 1 being written, dated directions, option 2, oral witness directions, and option 3, a directed to physicians. Importantly, a directed to physician is only effective once the primary attending has also documented terminal or irreversible condition, i.e. the patient is qualified. But once the patient uses one of those options, then the primary attending can issue the order. On the other hand, if DNR is medically appropriate, again, medically appropriate, there's no contrary instructions from the patient. Death is imminent, usually within minutes or hours, regardless of CPR. And otherwise, the DNR is medically appropriate, then the physician can go ahead and enter the order. You notify the patient first, and when possible, the guardian, agent, or surrogate, and document that notice. And you can issue the order, and then if you haven't already been able to notify the guardian, agent, or surrogate, notify them as soon as possible and document the notice. And for all these sorts of notices, document the name of the person you spoke with, their relationship to the patient, the guardian, agent, etc., and the date and time of the conversation. And don't place the order until you've given the notice unless absolutely necessary. In all situations, in all scenarios, scan all signed documents, directives, etc. Not that you didn't already know that. Not that I'm telling you anything new, but if it's not in the record, it didn't happen. So document, document, document. Scenario 1, when the patient has capacity to make. Scenario 2, the patient lacks capacity but is not qualified. And the patient doesn't have a documented terminal or irreversible condition. In this case, if a legal guardian has been named, then the guardian can use option 1, 2, or 3, just like always, and the order can be issued. If there's no guardian, but an MPOA agent is available, then the primary attending documents the incapacity. The agent uses option 1, 2, or 3, and the order can be issued. You'll note that we don't talk about surrogates here. Surrogates can only consent to healthcare facility DNRs for qualified patients. So if the patient does not have a documented terminal or irreversible condition, a surrogate cannot consent to a healthcare facility DNR. And the same, or at least similar, goes for medically appropriate DNRs or physician consent DNRs, because if the DNR is medically appropriate, such that the attending could issue a physician consent DNR, the patient would most likely have a terminal condition and would thus be a qualified patient. So falls outside of this scenario. Scenario 2, the patient lacks capacity. Scenario 3, the patient lacks capacity but is qualified. In other words, they have a terminal or irreversible condition that the primary attending has documented in the record. If the legal guardian is available, then the guardian can use option 1, 2, or 3, and the order can be issued. If there's no legal guardian, but there's a directive to physicians on file, the primary attending documents the incapacity and the terminal or irreversible condition or conditions. Follow the directive. Assuming that the directive says DNR, then issue the order. If there's no legal guardian or directive available or on file, but there is an agent under a medical power of attorney, the primary attending documents the incapacity and the terminal or irreversible condition or conditions, and the agent can use option 1, 2, or 3, and the order can be issued. Scenario 3, the patient lacks capacity but is qualified. Now, if we don't have a guardian, a directive, or an agent available, but there is a surrogate decision maker available, again in this scenario, surrogate decision makers can consent to healthcare facility DNRs, then a surrogate decision maker can use option 1 or 2, either a written, dated instructions or oral, witnessed instructions. And just to refresh your memory on the priority list, it goes spouse, reasonably available adult child, parent, nearest living relative, or 2 physicians. Once they exercise the option, then the order can be issued. If there's no guardian, directive, agent, or surrogate available, but the DNR is medically appropriate, notify the patient and, when possible, the guardian, agent, or surrogate, and document the notice. Issue the order, and if you haven't already been able to, notify. Notify everyone you can and document it. Now, if we don't have a guardian, a direct... So let's talk about liability. What happens if you do not follow the law here? Intentionally concealing, canceling, effectuating, or falsifying a healthcare facility DNR is a Class A misdemeanor, $4,000 fine and or 1 year of prison. Professional disciplinary action by licensing authority is also possible. This applies to physicians, physician's assistants, nurses, healthcare professionals, healthcare facilities, hospitals, other persons or entities. Now, let's note some unfortunate wording. Intentionally cancels or effectuates another person's DNR order. Wouldn't you intentionally effectuate a validly consented DNR order? Wouldn't you intentionally cancel a validly revoked DNR order? Well, of course you would. We just have to read the law with some reasonability goggles on here. It was worded poorly. You're not going to get in trouble for intentionally effectuating a DNR if it's validly consented, or intentionally canceling a validly revoked DNR order. And intentionally concealing or withholding personal knowledge of a revocation. Again, Class A misdemeanor, $4,000 fine and or 1 year in prison. It doesn't talk about professional disciplinary action, but you see there that you intentionally concealing or withholding personal knowledge of the revocation, that can get you in trouble as well. So if you know something, say something. So let's talk about liability. Limits on liability. We've talked about what the liability is. Now let's talk about what happens to limit that liability. A physician, healthcare professional, healthcare facility, hospital, or other entity who issues or acts on a healthcare facility DNR order in good faith does not incur any liability, civil, criminal, or disciplinary. That requires an honesty in belief and purpose, faithfulness to duties and obligations, and an absence of intent to defraud. The failure to honor a healthcare facility DNR order, if there's no actual knowledge of consent, no liability, civil, criminal, or disciplinary. There's no other protection there, though. If you have knowledge of it, you have to act on it or clarify your knowledge. One thing to talk about, though, suspending a DNR during anesthesia requires patient consent, and so it's allowed. The patient is consenting, is basically saying it's okay to suspend my DNR during the course of my surgery so that I can have anesthesia. We don't want people dying on the table if we can possibly avoid it. The healthcare facility DNRs will be suspended during anesthesia. The discussion has to be documented with the patient and the decision maker prior to the procedure. Failing to revoke a healthcare facility DNR order. If there's no actual knowledge of consent revocation, there's no liability. Again, same idea. If you don't know, no actual knowledge, no liability. If you have knowledge, though, you have to act on it. About a consent or about a revocation, if you have knowledge of one of those things, act on it. If you have hints, clarify them. Don't hide from them. If you don't know, though, you don't know. So, I mean, if you're going in and you're doing your best, you're honest in belief and purpose, faithfulness to duties, absence of intent to defraud, you're being a good actor. If you go in with that mindset, you're going to be okay. No actual knowledge, that's all right. One more time, though. If you have knowledge, act on it. If you have hints, clarify them. Don't hide from them. And if you don't know, you don't know. In short, be a good actor. Limits on liability. And that concludes our presentation on healthcare facility DNR orders. Again, my name is Michael Economides, Senior Associate Legal Counsel for UMC Health System. I look forward, hopefully, to being with you soon to answer any questions you may have, and feel free to contact me if you would like to at the number you see on your screen. Thank you very much.